Welcome to the October 15th, 2014 Planning and Zoning Commission meeting. If everyone would please turn off their cell phones or paging devices until after the meeting. And if you could please rise for the Pledge of Allegiance. Thank you. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Applications heard during tonight's meeting will be voted on by the Planning and Zoning Commission during the meeting tonight. Planning and Zoning Commission's recommendation on the applications requesting a rezoning or a conditional use permit will then be submitted to the St. Charles County Council for their final decision on these items. The individual items or bills will be introduced on Monday, November 10th at the County Council meeting. The Commission's vote on these plats is final unless a variance is requested or the plat is denied. The following documents are introduced as a matter of record for the public hearing and regular meeting of the Planning and Zoning Commission. Unified Development Ordinance of St. Charles County, including zoning maps, the year 2025 Master Plan for St. Charles County, which includes the year 2025 Future Land Use Map. And can I have a motion to open the meeting?
Second.
Thank you. All in favor? Aye. Thank you. Our agenda tonight, we're going to read the application, and the staff will give their recommendations. At that time, the petitioner will be asked if he would like to speak or not speak on the issue. And after that, if there are any people that object or have any other, would like to speak on that condition, they will be allowed to enter their opinions. And anybody speaking, Sheila has some cards over there, if you could fill them out with your name and address. And after the public discussion with any of the objections, the petitioner will have an opportunity to answer any of those if they choose, and then we will close the public hearing. We will discuss this amongst ourselves and take a vote. And with that, I'll start with the first petition on the agenda, which is application 24149, 200 South Park, Charles Boulevard, a PUD amendment. Staff.
Okay, thank you. The subject property, it is within the Park Charles South subdivision, and the area is zoned R1E with a PUD overlay, and all of the adjacent properties also have that zoning. Uses in the area include to the north, single-family residential, to the south is common ground, to the east is single-family residential, and to the west is attached single-family residential villas. This property has quite a history. It was originally built as a daycare center, the building was, and it has been used for a church counseling office, a private school, and most recently it was approved as a mortgage company. All of these were through the old RL zoning, which was in our 1973 to 1999 ordinances, or the R1E with a PUD designation. Now they want to convert this structure into a single-family residence. In order to do that, they have to amend the PUD plan, which involves coming before you and going before the county council. Staff is recommending approval of the use of the property as a single-family residence since it is surrounded by single-family residences. A revised final development plan must be submitted to and approved by St. Charles County. All pavement on the site shall be removed with the exception of a 20-foot wide drive to accommodate 2 parking spaces. Only one entrance to Park Charles Boulevard South shall be permitted. A permit from the St. Charles County Highway Department must be approved for the removal of the second entrance. And the structure shall meet all property maintenance and building codes for single-family residential structures. So we recommend approval subject to those conditions, and there were no letters.
Is there any questions for
Questions?
staff?
Thank you.
Would the petitioner like to speak?
Hello, my name is Scott Sacco with Keller Williams Realty West. I'm representing the seller of the property, and we appreciate the opportunity to come forth today to get this approved as a residence. We've looked at this. Oh,
One boo-boo.
Sure.
Could you please raise your hand
sure.
and have to
That's
swear
right.
you in? You do swear to tell the whole truth and nothing but the truth, so help you God?
Yes,
Thank
I
you.
do. So I've worked with this property over the years. I've sold it as I represented the sellers for a daycare, and it was sold to a church, and worked with it for various years. And just recently, we've endeavored to sell the property, and we've looking at it, just throwing it out there at the market, whether it was residential or commercial, and it seems like there's much more interest, and I think residentially is the way to go with this. Less improvements would have to be done to meet the county requirements as far as conversion, and I think that would be much more satisfactory to the neighbors. So that's what we'd like to do. We do appreciate the staff's recommendation to approve. However, the parking lot, there's an existing parkway there that's there, it's been there for quite some time. And with all due respect, we'd like to leave that if we could, for various reasons. The parking lot that's there now, the drive lanes have been there for quite some time. Whoever buys this as a residence would likely want to put a garage on the back side. And there is sufficient area on both sides of the property to create a driveway on the back side. But we don't know where somebody would want to put that garage, if they would want to put it, on the east or the west side of the property. And it would also be a financial hardship to remove that, to make this conversion into a residence, and then have to remove all that before they can even move in. We'd sure like to have the opportunity for somebody to move in the house and get it fixed up, get somebody living in it, and instead of having it vacant, and perhaps address the parking lot at some point in the future. At some point, they're going to want to remove that as a residence, and they're going to want to have a front yard. But to have them do that now, get it all prepared as a residence, put a garage in the back, it's just, I think that's asking a great deal for somebody to come into a house that, it's not a conventional house, so it's going to be somebody that has a vision. Based on the hardship and based upon all that, I hope that you'll approve this as a residence, single-family residence, but not require. And also, the highway department's got to require to remove one of those driveways. So that's additional steps we'd have to go through before somebody could use this property as a residence. So for all those reasons, we appreciate that we get this approved without the conditions for removing any of the driveway as shown as it is today. Thank you very much.
Would anyone else like to speak for or against this proposal?
I would like to ask him a few questions, actually, Scott, if you want to come back up.
Sure.
So if
Yes,
we
sir.
vote with the use or the recommendations of staff, are you not going to want it to be changed then?
No,
Because there's recommendations to take that driveway out.
No, I think we would still want to do that, but I think it's just going to be more difficult to find a buyer who's willing to pay more
Okay.
for the money, to spend the money to get it improved, to do that. I mean,
Okay.
the seller's got, we got to net a certain amount of money, and
Right.
so if it costs more to get it before they can move into it, it's just a function of economics,
I
really.
just want to make sure you understand if we vote on it and we're with the recommendations, then that's the only way it can be
Well,
done, I'm
I just,
assuming.
yes, I think that we want to go residential with it, and we can't
Okay.
sell it right now without residential, without having this contingency. So we'd still like to move forward with that, and we just hope that you're lenient on that. And maybe if we have to, Jan and I talked about maybe something in the future, perhaps, maybe removing it after a period of time.
Okay.
I'm just trying to be sensitive to somebody wanting to move in there, how much expenses are they going to have in acquiring the building and then retrofitting it on the inside to make it more of a residence, to make it suitable for them. So it's a tough piece of property and stuff there, and we're just trying to make it as affordable and economical for somebody to go in there, and more expense is loaded into making the conversion. It's going to sit longer until we find that person who's going to be able to utilize it.
Roger, you have a question?
Question for staff. Other than the removal of the second driveway by the County Highway Department, there isn't anything that says I can't have a front yard of concrete, is there?
In the UDO, we do limit maximum width of a driveway to be the width of the garage, or 30 feet maximum. This house doesn't have a garage, so, I guess we'd go the 30 feet maximum. But this, if we convert it to, well, you can approve the plan as is, because through the PUD, you can vary all of those residential type requirements. Like we could have, a one-car garage or something like that, if you wanted to within the PUD. So you guys, it's within your power to do that. You can remove those conditions, and then the plan is approved as is with all that parking out front of that place. Or you could put some conditions on a time frame when you want the parking reduced down, to accommodate one entrance or something like that. So you have like 3 options. You could go with the staff rec, or vote with the staff rec, but remove those 2 conditions, or put a time frame on it that they have to complete it.
Yes.
I guess I wished I had a circle driveway in the front of my house. And I could see where somebody would possibly add a garage to the rear later on and saw cut some of that out there.
Yeah, mother of 3 kids. Oh, yeah.
And I'm very familiar with this subdivision. I don't know that the traffic is that bad on a residential street, and I don't think it would be a real problem myself. I don't know how dead set the staff is, but.
We really want this to be converted to a single-family residence.
So do I.
I think the neighbors do too.
If there's no other comment or questions for the petitioner, I guess we'll close the public meeting, and then we can,
You can open up to,
I did that
Oh.
before. There
Oh,
wasn't
yeah.
anybody that wanted to speak. Discussion amongst us. My knee-jerk reaction, if you look at all the other homes there, they all have driveways, and, which I can understand the economic impact on that. But on the other hand, to make it look like a residence back to where the rest of the community is, I would think if it would ease the burden is to put some type of time limit on, put the limitations of the width of a driveway, and I'm assuming, probably from a neighbor's standpoint, it would be on the right side of the house. It would be a clone of the house next to it, and the houses that are in that cul-de-sac that swings around, it would be farther away from that. But I would think my opinion is, if somebody would come to an agreement that's reasonable, put some type of time frame, leave it as is, and then the rest of the parking spaces be removed at some future time. Otherwise, it's gonna be a parking lot out there. And that's my opinion. Anybody else? Yes, Mr. Herman.
I guess I'm looking at this and I see the duplexes right next door to this, and they have dual driveways. I don't know that it's that big of a problem for me, to allow them to have that. I mean, if people wanted to add additional concrete to the front of their house, they could do that. I don't see as a big sticking point with this project.
Anyone else?
So if the house that's on the right-hand side of that picture wanted to do the same thing, is there anything in the ordinances saying that they couldn't do it?
Yeah,
There is.
yeah.
Okay.
And that would be,
I would go with Jan's comments. Been on the board for a long time. We've seen this property time and time and time again
Yeah.
throughout the years. And the resolution obviously is a single-family residence. The troubling part, I think, is the economics that he's talking about here. So I would say, let's go with Gary's thing and put a 2-year hiatus here. And we can, then when this comes back with a PUD, if we want to strengthen it or weaken it, it can be done at that time.
Agreed.
But for tonight, just put a 2-year, within 2 years, 24 months, or however you'd say that. That's my speech.
Would we have a motion to approve with that condition?
Amend
Or amend that condition?
number 2.
And Bob, how would we use the language for that?
That they have 2 years to comply with recommendation number 2.
Yeah,
That's the all pavement on the site shall be,
remove to the
Yeah.
30-foot, right.
I'm just
as
making
worded.
sure that all pavement just refers to what's there now. Shall be removed with the exception of a 20-foot wide drive to accommodate 2 parking spaces, yeah. Within 2 years of date of approval.
And what about condition 3? Do you want the 2-year time frame on that one as well? If someone wants to move that.
What was 3 again?
Number 3 is only one entrance to Park Charles Boulevard South.
That has a double driveway.
Yeah.
There, they'd have to take one of the driveways out.
I would leave that, the same thing, I guess, with a 2-year condition, applying to
Keep it simple.
2 and 3.
Yep. Do they have to come back before us if they want to not remove that in 2 years to ask for
Yeah,
another
then
extension?
they would. They'd have to have the condition.
Yeah, okay.
Varied.
So in reality, they're gonna have to remove it. So you understand that, don't you, Scott? I mean, in a way, if we do it that way.
I mean, couldn't we do a circle?
It's gonna make it hard for you guys to sell the property regardless.
Can we
I
remove
think.
the middle part and put grass there and have a circle drive? 2 entrances, leave the 2 entrances?
I don't know, I guess it's,
But then you don't have then you don't have a garage.
well, I guess you could still have.
well, the garage is in the back.
Yeah, you could have it still, and it'd be in the back, yeah.
Still just on both sides.
Yeah, that's my, Jan, could they go in and take the concrete saw and, with the existing concrete that's there, and cut out a circle driveway? Or is there a limitation, it's they'll have only one entrance?
Well,
And then put the garage in the back?
yeah, I mean, the only one driveway that kind of came out of our one-step meeting from the highway, that came out of the one-step, I'm sorry, that came out of the one-step meeting from the highway department. But if you want to allow them to have the 2 driveway entrances, I mean, you can do that, because you can approve the plan that they have the 2 driveway entrances, and make the circle drive. If they have the 2 driveway entrances and a circle drive, we're probably not going to end up with a lot of green space in front of this house. Because to maneuver a car around, it's pretty tight there. But, I mean, if you're going to have the 2-year time frame on the other condition, I would say you probably want to have the 2-year time frame on this condition as well.
Is the highway department going to allow that? Like a circle drive having 2 entrances?
Since there's already 2 entrances there, if that's what you guys approved, I think they would have to abide by that.
So would we have a motion to approve with those addendums on those 2 conditions, condition 2 and 3?
So moved.
Second.
Mr. Setley, how do you vote, please? Mr. Setley, how do you vote?
I vote yes.
Mr. Ellis?
Yes.
That's just an either or.
Mr. McBride?
Yes.
Is that
Mr. Galen's not here. Mr. Leonard?
Yes.
being added? Okay.
Mr. Fram?
Yes.
Mr. Kuhn?
Yes.
Ms. Polly?
Yes.
And Mr. Hammond?
Yes.
And I vote yes. So the motion carries 9-0. The next application for review is application 24485. Staff.
Sorry. Okay, this is a request. Oh, wait, we're gonna have, how about 24357?
Yeah, that was what was next.
Okay,
Okay.
sorry. 23457.
Okay, this is a request to re-subdivide a lot in the Highland Trails subdivision. This subdivision, we've approved 5 other re-subdivision plats in the subdivision. We had approved a re-subdivision plat in like 2007. There was a court case. The people of the subdivision said that the approval violated their subdivision covenants and restrictions. It went to court, and you have a copy of that court finding that the amendment to their subdivision covenants that prohibited the splitting of lots was not a legal amendment to their subdivision covenants. So therefore, that subdivision, the court ordered that we approve that subdivision, re-subdivision plat. And so when we have approved 4 other re-subdivision plats. The property just to the east of this, this one is a re-subdivision plat. And there was also a re-subdivision plat across the street from it. The plat meets all of our requirements, and staff is recommending approval.
Is the petitioner here who would like to speak? If you please raise your hand. You state your name, and you swear to tell the whole truth and nothing but the truth. So
Yes,
help you
I'm
God.
Dale Walterman, and I do. I'm with Dale Walterman with Landmark Survey, and I'm representing the Higgins of petitioners. And as usual, Jan's pretty much said everything that needs to be said about it. I've got nothing else to say unless you have a specific question of me.
Anyone have any questions?
Nope.
Thank you. Is there anyone here that would like to speak for or against the petition?
Good
And
evening.
could you please state your name and address and
David Diamond, 14 South Trail, St. Peter's, 63376.
and you swear to tell the truth and whole truth, so help you God?
I do.
Thank you.
Good evening. I'm David Diamond. I think the committee received a fax, my letter. The law firm is the Traffic Law Headquarters. I faxed it yesterday, I believe. We also mailed the original, but you probably didn't receive it today. But I oppose the re-subdivision of the lot, and I'm referring to the original declaration and covenants. It says no lot located within Highland Trails Plats 1 and 2 shall be split or subdivided with the exception of Lot 65, which has been previously split by its owner with the approval of the Board of Directors. This is the original covenants. The judge ruled against the amended covenants, but the original says that the lots cannot be subdivided. If necessary, we'll file for a rehearing, and if we lose, we're going to appeal. But we're going to fight this as far as we can, all the way to the Supreme Court of Missouri if we have to. But I believe the judge ruled incorrectly in 2006. And regarding, I'd like to propose and assert some more arguments to this, but the notice that we received, we didn't have a lot of time to prepare, so I just wanted to get it on the record that we oppose the subdividing of the lot. Thank you.
Thank you. Anyone else would like to speak? Would the petitioner like to respond to the...
to say, except that it does comply with the zoning. It is allowed within the zoning of that area. So it's zoned to be re-subdivided, and it is on central sewers, so we comply with that also.
Would anyone on staff like to address any of the speakers?
No, I have a question for staff.
Okay. With that, we'll close the meeting, and then we'll open it up to discussion amongst the commissioners. John? Or Dave, sorry.
So this is currently zoned for 1 acre lot? And since the attorney's here, it's my understanding that as being on the county board, that we can enforce the regulations of St. Charles County, but we can't enforce covenants or restrictions. Is my understanding, is that correct?
That's correct.
Thank you.
So what does that mean?
To take it a little bit further, you can take into account what their subdivision covenants, bylaws may be, but it cannot govern your decision.
I got you, okay. And there has been other lots that have been subdivided, and because he's saying there's only one, and that was 65?
Right, but there have been 5 re-subdivision plats since
Okay.
2007.
And have you guys opposed that, then? I'm wondering if they're, are you new, David, are you new to the subdivision then? I guess you are, okay.
So I hope you understand the predicament we're in, that we have to follow county laws, so we can't follow private restrictions.
Yeah, it's fine.
Any other discussion, comments?
Well, I remember these well, and I think I voted against every one of them when it came through, but things have changed somewhat, the sewers and the water is out there now. Before, that property, several of them were bought on the courthouse step for back taxes. And it was straight economics, like, let's split this in 2 pieces, and the defendant stood right there and said he was gonna build a house there, which was total ballyhoo. He lived on a golf course up in Wentzville, and he had no plans to do that. He just got it on a tax lien and split it in 2, so he got more out of it. But they won in court, and now there's sewer and water out there, and an acre's a pretty good-sized lot.
Any other discussion or comments? Well, that, we'll ask for a motion to approve.
So moved.
Second.
For it.
Mr. Ellis, how do you vote?
Yes.
Mr. Fram, how do you
Yes.
vote? Mr. Hammond, how do you vote?
Yes.
Mr. Kuhn, how do you vote?
Yes.
Mr. Leonard, how do you vote?
Yes.
Mr. McBride, how do you vote?
Yes.
Ms. Polly, how do you vote?
Yes.
And Mr. Sutley, how do you vote?
If I wanted to be consistent, I would vote no, so I would be consistent and vote no.
So and I will vote yes. So the measure passes 8-1. The next thing on the agenda is application 24485. Staff?
Okay, this application is something different from what we normally do. We're calling it administrative review of a final plat. We received the plat, let's see if I can. We approved this preliminary plat for Enon Branch Estates this summer, I guess. And what they have submitted is this, which is a smaller, reduced-down version of the plat. Since we approved the preliminary plat, that takes in more area, which in this case is to the north, to the left of the screen. When we do that on a preliminary plat, we want the street to stub into that next property so that we can have plat 2. From what I understand, there's a family that's a dispute, and Dale can probably answer this more than I can. And so they have, or I shouldn't say that they're in dispute. The people who are going to get the rear portion of the property don't want a stub street to it. They have no designs on further subdividing that piece of property. So they brought us in this final plat that shows this cul-de-sac. We as staff think that, you know, we're being short-sighted in not having that street go through, because 50 years down the line, that may go through, and then we've got troubles. And, you know, if a house gets built right at the end of the cul-de-sac, the street's not going through, they'll have to get around it through any other means. So that's why we are bringing it forward to the commission, because so basically, you guys get to decide if you're going to say, this is okay with this cul-de-sac, or no, it's not okay, and it needs to have a stub. And it's a provision in the final plat requirements of the county that, that if staff doesn't find that it meets the preliminary, basically, you guys decide.
Any questions for staff?
Yeah, when this first came before the commission, there was a lot of discussion about the flooding here.
Actually,
And I see no markers on here.
this portion of the plat would not be in the floodplain, and on this approved preliminary, the floodplain is down in this area with 3-acre lots. We allow portions of the lot to be in the floodplain. When this came to us a few years ago, it had, on the current flood maps, it has a lot more floodplain on it, but it's unstudied unstudied A zones. And so now we have the new D firms. We can't regulate everything by the new D firms, but we can certainly use the new D firms when we're doing subdivision planning, because the D firms will soon be in force, and these people will be, their insurance will be based on the new D firms eventually. The topography of the site is such that even if they built at the end of this cul-de-sac, they aren't going to be in, the houses will not be in the floodplain, because there's a topographic change, of course, down to the flood area. So, I mean, it's not really an issue any longer on this plat.
But wouldn't that be shown on here? I assume that if I was
Well,
going to
no, this one does not go as far to the north as the other. I don't know if I can put them both up side by side, and you can. This line at the end of Lot 4 corresponds with this easement, the power line easement. And the floodplain is in this portion of the site. So this plat that they've submitted, it doesn't go into the floodplain area.
And what are you worried about on the road again? That would not go through?
There's no.
Right, because this,
Right.
normally we would require a stub street here.
I gotcha.
So that you could get back to these lots. And what they're proposing is
'cause you
to have a
explained-
cul-de-sac.
Okay.
And then
It was originally zoned
these
for
lots would
yeah.
get access through a private easement over here.
I got you. Okay.
So
Or not those lots, that piece, because they couldn't subdivide it.
the piece in the back, there's no current ingress or egress to it?
Correct, they are gonna have to establish a new easement of access, and that's gonna limit them from being able to split it.
Be able to get to it. I guess
Mr.
it's
Chairman.
on a name road.
Yes. Mr. Hammond?
How big is that parcel that's on the other side where you want to stub this out?
I have to. Okay.
They have larger lots.
Are these all on septic?
Yeah. Yeah, septic and well, I'm
And
pretty
wells.
sure.
If I could mention something, to me, the magic words are landlocked parcel in the back. So a landlocked parcel is going to be created in the back. It is technically going to have an access easement so you can get back to it, but the access easement is so long from the main road. Is it ever going to be economical to build a street that long out to that landlocked parcel? I think the safest thing to do would be to build a stub street so that someday that could be developed. But I suppose if someone insists that they never, ever want to develop, that's one thing you have to weigh. But on the other hand, when you create a parcel, it's going to be there for 100+ years. It's going to pass through numerous hands. And so I guess that's the question for you tonight, whether to extend a stub street past that cul-de-sac to dead end of the property line.
So are you saying that someone could buy that piece back there from the subdivision, and they want to stub in a street from the other access road? Why would we care if it costs them that much?
Well, I guess the question is this going to create a landlocked parcel that can't be developed at some point, just because of the economics and
So
things
why are
like
they
that?
doing that then? I'm kind of curious of that. Well, I guess we can get them up here and find that out.
Any other questions for staff? Would the petitioner, you please state your name and address?
Dale
and
Walterman, Landmark Surveying, 802 East Main Street.
Swear to tell the truth and whole.
Yes, I do. This belonged to the heirs, which were 6 siblings, so that pretty much tells you there's a problem right off the bat. So 4 of the siblings sold out to the 2 of them. Okay, the one in the front wants to develop, and the one in the back, which we took off the final plat, she doesn't want to develop. But as of Monday, she's had second thoughts. She thinks she probably really would be in her best interest to have that stub street. But now I told her to get with her brother so we could decide on this, and they haven't decided, and I've been sick in bed for the last 2 days, so, I mean, can we table this till next month?
Might be a good idea.
If the commission chooses to, yeah.
If you'd
It doesn't make any
like to do
difference. We
that,
still got to go through improvement plans, and God knows how many months they're away, so it's not going to hurt anything.
if you would like to do that, I'll make a motion.
Yeah.
We'll table this until
Yeah.
next month.
Well,
Yes.
Do we have a second? All in favor, say aye. Aye. So we're tabled until next month.
we just hope that within 30 days they come to an agreement.
Good luck.
I would pass along to them, I mean, I support the staff on that, there being a stub street there to get back there, so they may have to do that anyway.
And the final application, 23790, I understand has been tabled. We have a motion.
It's still on the table.
It's on the table. They would like to have it tabled. Do I have a motion?
No, we'd have to have a motion to remove it, so.
Oh, okay.
yeah.
We'll leave it on the table.
Yeah.
Do we have everybody in favor of that?
Well,
leaving
no,
it
we
on
don't have
the
to do
table?
anything.
We don't have to do anything? Okay,
Yeah.
It just stays on the table.
okay.
It just stays there. That's what we do.
Do we have an approval for the meetings of September 17th, 2014?
So moved.
Second.
All in favor, say aye.
Aye.
Any other business?
Motion to
Besides-
adjourn.
Motion to adjourn.
Second.
All in favor?
Aye.
Aye.
Thank you. Then what's-